We're here in the matter of Redina or Redding?
Redding, Your Honor.
Redding versus French, 35 CL1, 1505 CT 78. Mr. Hallam on behalf of the plaintiff, and sir, you are?
Attorney Midway on behalf of the defendant.
Okay. We're here on a motion for summary judgment. Your motion?
That is correct. That's motion, Your Honor.
All right, we're ready to proceed?
Yes, Your Honor.
All right.
Your Honor, the defendant has brought a motion for summary judgment asking the court to dismiss this case as a matter of law. Now, as the court knows, summary judgment is usually not a good vehicle for cases that involve negligence, premises liability, sort of thing. But the defendant submits that in this particular case, it is. And the reason being is that the plaintiff has a duty to prove the elements of the negligence claim, which is duty, breach, causation, and damages. And in this case, plaintiff cannot show that there is any duty on the part of my client with regard to this tree that's at issue here. Now, this is a case about a tree that purportedly fell down and struck the plaintiff. This tree was located in the little plot of land between the sidewalk and the street in front of my client's home. Now, the facts are really not in dispute in this case, Your Honor. It's clear that my client owned the home that's located at 930 72nd Avenue in Marigold. That's undisputed, I think, and the plaintiff has not presented any evidence to the contrary. What we have presented to the court is a surveyor map of my client's property. And that map shows that my client's property line cuts off at the sidewalk. So he doesn't own that property between the sidewalk and the street. And it's undisputed that this tree that's at issue here was located in that plot of land. Now, the town of Marigold does have a right-of-way that runs right across that. So it's our position that that property actually belongs to the town of Marigold. Now, in order to have a duty imposed on my client, there has to be a basis for it. It's clear he's not the landowner, so he doesn't own that plot of land where this tree is located. The plaintiff tries to argue that he had a duty because he controlled that plot of land. Well, that's absolutely not true in this case. It's located in front of his home, but again, he didn't own the home. And we've cited to a Marigold ordinance that prohibits him from removing trees that are on Marigold property. So, by law, he can't remove that tree without permission from the town of Marigold. And that's at issue here. He purchased his home in the spring of, I think it's 2013 was the year of this incident. The incident was September 1st, 2013. He purchased his home in the springtime and only owned it for 4 or 5 months or so when this incident happened. Now, plaintiff tries to point out certain things that my client did to show that my client supposedly controlled this plot of land. My client admits he shoveled snow on the sidewalk area. My client admits he mowed the grass in this little plot of land in front of his home. But he did so because, in his experience, that's what he has to do. When he lived in Illinois, and we presented his deposition testimony, when he was living in Illinois, that's what he saw all his neighbors do. When he moved to this neighborhood, that's what he saw all his neighbors do. And we know as homeowners, hopefully the people who are homeowners know that if you don't shovel the snow in front of your sidewalk, somebody might fall. And you might get a ticket from the town if you let the snow accumulate too long. So just because he did these things does not evidence any control of this property. He did this because if he doesn't, he's going to get a ticket. He can't just sit there and let the grass grow too long, or else he's going to get a citation from the town of Marigold for a violation. So we submit to Your Honor that the evidence shows clearly that, number one, he did not own this plot of land where the tree was located. Therefore, he has no duty in which to remove this tree. Secondly, he doesn't control this property. He may have maintained it, but he actually doesn't control it. And more importantly, he has no legal right to remove that tree without the town's permission. And in this case, Your Honor, that's the bare facts. Those are the undisputed facts. Now, plaintiff cites to some cases. Those cases are not applicable for this fact scenario here in our case. One of the cases cited talks about the owners of land. And I believe the case was Marshall versus Erie Insurance Exchange. And it talks about how the Supreme Court imposed duty on landowners in residential populated areas. But again, there's no facts that show my client owned this plot of land where this tree belongs. Plaintiff also cites to Ballinet versus Eskew, and that case is also inapplicable because that talks about a possessor of land, but he wasn't a possessor of that land. It was in the right-of-way of Maryville. So it's Maryville's land, really. And plaintiff also cites to a definition of possessor in the case of Jackson versus Scheibel, found at 902 Northeast 2nd, 807. And all of this is in plaintiff's response to our motion for summary judgment. But that definition of possessor was in the dissenting opinion. It wasn't the court's definition of possessor of land. So what do we have here, Your Honor? We have clear facts that are undisputed. My client did not own this land, and my client had no duty to remove this tree. Therefore, summary judgment as a matter of law must be granted, and this case must be dismissed, given that my client has no duty to remove that tree.
Okay. Howell?
Your Honor, my associate, Kate Howell, will be arguing.
Okay.
Your Honor, first, defendant mistakenly argues that because the dead remnant of a tree, also known as a snag, was on the town of Maryville's right-of-way, that the defendant was not the landowner and therefore didn't owe any duty to remove it or to safeguard it from injuries resulting from the falling. Defendant misinterprets that the town's right-of-way means that the town owns that land. A right-of-way is a type of easement on Mr. French's land. Indiana Court of Appeals in Huffman v. State noted, quote, "It is the firmly established rule in the state that the owner of land abutting upon a public highway owns the fee to the center thereof, subject only to the easement which the public has for highway purposes." Black's Law Dictionary defines a right-of-way as follows. The right of passage or of way is a servitude imposed by law or by convention. It is a mere easement in the lands of others. The United States Supreme Court acknowledges, quote, "The term right-of-way has a twofold signification. It's sometimes used to describe a right belonging to a part, a right of passage over any track, and it is also used to describe that strip of land which railroad companies take upon to construct their roadbed. Because a right-of-way is a type of easement imposing a servitude on the land, the Indiana Court of Appeals in the town of Ogden v. Wildermuth found that, quote, "An abutting landowner to a right-of-way has the right to make any reasonable use of the highway which does not interfere with the enjoyment of the public easements." Furthermore, it is well established in Indiana that landowners in urban or residential areas have a duty to inspect their property and take reasonable precautions against dangerous natural conditions and to prevent trees from posing an unreasonable risk of harm to passing motorists. Thus, the defendant's duty as landowner to care for or remove this snag is not erased merely because the town has a right-of-way easement on that part of his property. Second, defendant erroneously claims he was not a possessor of the area in his front yard and didn't control the area of his front yard where the snag was located, and thus he had no legal duty to exercise reasonable care to prevent an unreasonable risk of harm arising from the snag. Indiana courts have defined possessor in part as, quote, "a person who is in occupation of the land with intent to control it." And that's from Jackson v. Scheibel. Now, the defendant incorrectly states that such definition was not the majority opinion of Jackson v. Scheibel, but merely the definition relied upon by the dissent. However, plaintiff cited the definition on page 810 of the case reporter, which is within the majority majority opinion. And it just so happens that the definition relied upon in the dissent is partly the same definition, but that is not the definition cited and relied on by plaintiff. In defendant's memorandum in support of his motion, defendant agrees that the question of whether a duty is owed in premises liability cases depends primarily upon whether the defendant was in control of the premises when the accident occurred. Here, defendant argues he was not in control of that area of his front yard where the snag was located because even though he mowed the grass on his entire front yard, he was not told to mow the grass on the part of his yard that's in between the sidewalks and the street. Well, it doesn't matter why the defendant mowed the grass on his entire yard. The mere fact that he routinely mowed the grass in his front yard, including in that area of the town's right-of-way where the snag was, that shows he controlled or meant to control the area. Defendant also argues he was not in control of the area where the snag was located because he didn't plant flowers there. However, just because a person doesn't plant flowers in his front yard doesn't mean he doesn't exercise control over his yard. There's no set minimum amount of flowers a person must plant in his yard in order to show he controls that area. And similarly, the defendant argues that the fact that he puts his garbage can in the street rather than on his driveway shows he doesn't control the area where the snag was located. But the placement of a garbage can for collection is not dispositive of whether a person controls an area for purposes of premises liability inquiries. Additionally, defendant wrongly claims that because the town ordinance prohibited property owners from taking certain actions in the town's right-of-way, such as building a permanent structure, that shows defendant was not in control of the area where the snag was. Well, easements or right-of-ways can have limitations without taking away a landowner's duty to care for his property to protect people on a public road right-of-way. Also, defendant occupies the property as his primary residence, and he exercises his control over his front yard, including this area in which the town has a right-of-way, by mowing the grass and shoveling the snow on the sidewalk in front of his home. Defendant admits the town doesn't mow the grass in the area of its right-of-way easement. The town doesn't shovel the snow off the sidewalk in the right-of-way easement. Mr. French is the only party with actual control over the condition causing plaintiff's injury. And as possessor and when in control of the area, he has a duty to exercise reasonable care to prevent an unreasonable risk of harm arising from the snag. Third, defendant incorrectly claims that he was stopped from performing any maintenance on the snag because of Maryville Town Ordinance 10-23. Plaintiff points out that defendant's cited ordinance relates to trees located on public-owned property as well as to trees on property in the public right-of-way. This ordinance allows for the removal of dead wood as well as for the correction of, quote, potentially hazardous conditions in this section entitled pruning. Now, defendant wrongly argues that pruning means only to cut off some branches of a tree, citing Merriam-Webster Dictionary. However, that is only a part of the definition given by Merriam-Webster. The complete definition of pruning is as follows, quote, to cut off some of the branches of a tree or bush so that it would grow better or look better, to reduce something by removing parts that are not necessary or wanted. The part of the definition of pruning given by defendant is irrelevant to the case at issue because this was a completely dead, limbless tree, not something that could have had branches cut off so it would grow or look better. Instead, the second part of the definition is relevant here because it involves removing parts that are not necessary or wanted. In this case, defendant could have removed the snag, which was unnecessary to the tree once because it was completely dead, and it was now just an unwanted, potentially hazardous condition to those using the public road right-of-way. The snag could have been pruned either by removing it completely, as defendant later did with a chainsaw, or cutting it all the way to the ground. To be clear, plaintiff never claims the town ordinance gave rise to a duty requiring the defendant prune the snag. Defendant's duty as landowner, or alternatively his duty as possessor, required him to do something to make his property safe for people using the public right-of-way. The ordinance allows a person to remove the snag or cut it down to the ground. Thus, the ordinance in no way prohibited defendant from removing the snag located in the town's right-of-way easement in his yard, as defendant incorrectly claims. In conclusion, the evidence is compelling that the defendant owed plaintiff a duty as the owner of the property in front of which is a town right-of-way containing the snag, and also as one who possessed and actively controlled that property. And these facts preclude the entry of summary judgment in favor of Mr. French.
Okay.
Your Honor, I heard absolutely nothing from plaintiff in oral argument and nothing presented in way of their response that says Mr. French owned this property. We have a survey that shows Mr. French's property line cuts off before the sidewalk. So where's the evidence that my client owned this property from the sidewalk to the street? Now, there's a lot of talk about right-of-way. We're not disputing Maryville had a right-of-way. All we're saying is my client did not own that plot of land. And it's the plaintiff's burden to prove my client owned that plot of land in order to impose a duty on landowners, and they haven't done so. So then the question becomes control. What I didn't hear from plaintiff, and what I don't see in any of the submissions, is where do you get around Maryville Town Ordinance Section 19-226, which states, and I quote, "No person or persons other than those under the direction of the town of Maryville, the Public Works Director, the Parks Director, or their designee, or NIPSCO, contracted line clearance certified arborists, shall remove, install, or perform maintenance on trees located on public-owned property." Well, I don't know who owns this property, but it's clearly not Mr. French. So if it's not Mr. French, it probably belongs to the town of Maryville. Now, Mr. French testified in his deposition, and we submitted that to Your Honor. He's aware of other public works projects in Maryville. He lives in Maryville. And he was aware of a project that was done on Taney Place, over near 30 and Taney Place, where the town came in and repaved that whole street of Taney Place. And the town redid the sidewalk areas and the curb areas. That was the town's project. That's the same area we're talking about in front of Mr. French's property. That's what the town of Maryville would have done or will do in the future for Mr. French's property when his street becomes in disrepair. So plaintiff fails to their burden in showing there's any duty owed by my client. He's not the landowner. He didn't control this. And just because he mowed it, again, doesn't show control. Okay? He has to mow it, because if he doesn't, and if he doesn't do certain things, he's going to get an ordinance violation from the town. I mean, the town cites people for things like not having the pool enclosed, and that's on your own property. The town has a legal right to cite you for that. The town also can cite you for violation of Section 8-2-B that says no person shall throw garbage upon their property. And that's on your own property you can't throw garbage. So clearly there are certain things, and one of the things is Section 13-2-1, they can cite you for high grass and weeds. And if Mr. French did not mow that yard, he would get a citation and have to pay that. And then he'd have to mow it anyway. It's not his, he didn't assume the responsibility. He had to, by law, or else he's going to get fined. And so does every other property owner out there. So there's no control here. He says he can't plant anything on there. He can't build anything on there. How is that control if he can't do anything with it other than just maintain it as the town requires? So I submit that plaintiff has utterly failed to show any duty, and this case should be dismissed. Thank you, Your Honor.
Okay. All right. Let me again review the briefs, my notes from your oral arguments, and I'll issue a decision. Okay?
Thank you, Your Honor.
Thank you.
All right.